On January 19, 2024, just after midday, the steps outside the Royal Courts of Justice in London fell unusually quiet. The cameras were ready, reporters waited, but there was no statement, no pause for questions. Prince Harry emerged through the heavy doors, jaw tight, eyes fixed forward, and walked past the microphones without a word. What looked like a routine exit was, according to people present, the moment a long and expensive legal gamble collapsed. Inside that building minutes earlier, the High Court had delivered a ruling that did not just weaken his case, it effectively erased most of it. This was not a dramatic verdict read aloud for the public. It was procedural, technical, and devastating. The kind of decision that ends years of planning without raising its voice. Court staff noted the change immediately. What had begun as a confident appearance ended in visible strain. For months, this case had been framed as a personal crusade. Harry had positioned it as a fight about principle, ethics, and accountability. He had spoken publicly about wrongdoing, responsibility, and the need for truth, but inside Courtroom 73 the focus shifted to something far colder: dates, timelines, calendars. According to legal observers, one narrow question began to dominate everything else. Why now? That question mattered more than any testimony. Under British law, claims are bound by strict time limits. Miss them, and the court may never reach the substance of the complaint. Sources familiar with the hearing say this issue hung over the room long before the ruling was finalized. When the judge began addressing it directly, the atmosphere changed. Several people inside described a brief pause lasting less than 20 seconds when it became clear where the decision was heading. No objections were raised, no documents were passed. A quiet understanding settled in. The legal strategy depended on persuading the court to reopen the clock. That argument did not land. What followed was not just the dismissal of claims, it was the start of consequences that extend far beyond reputation. In the UK system, losing does not simply mean walking away. It can mean paying for the fight on both sides. Legal analysts quickly began estimating the exposure. The numbers were not small. Outside, Harry's silence stood out. No denial was issued, no clarification offered. His legal team declined immediate comment. For someone who has spoken often and openly about this battle, the absence of response was notable. This raises the central question that now hangs over the entire episode. Was this ever a case the court could win, or was it always a moral fight placed inside a legal system that does not reward timing mistakes? To understand how it reached this point, and why the fallout may only be beginning, the story has to be rewound to the choices made years earlier. For Prince Harry, this courtroom defeat did not begin in January 2024. Its roots stretch back nearly 2 decades, to a period when he was still a young royal living under intense public scrutiny. In the mid-2000s, as tabloids competed aggressively for stories about the royal family, illegal information-gathering practices became an open secret in British media circles. Phone hacking, private investigators, and questionable sourcing were later exposed through multiple high-profile inquiries. At the time, Harry was not alone. Senior members of the royal family were affected. According to publicly discussed records, dozens of journalists were later implicated across several outlets. Civil claims followed. Settlements were reached. Criminal charges were brought in some cases, but not every potential claimant moved at the same pace. Sources familiar with palace legal strategy say there was an informal understanding that litigation would be handled cautiously. The monarchy, as an institution, traditionally avoids public court battles that risk exposing internal communications. The goal has often been quiet resolution rather than public confrontation. This approach shaped how claims were addressed behind the scenes. Harry, by his own account, believed he was advised to wait. He has stated that pursuing legal action earlier was discouraged. He later framed this as restraint imposed by the institution. That belief became central to his argument years later, but at the time there was no public challenge, no filing, no visible dispute. Between 2011 and 2015, other figures began settling claims. Some received compensation, others accepted apologies. According to people familiar with those negotiations, discretion was prioritized, details remained sealed, the public largely moved on. Harry's situation changed dramatically after 2018. His relationship with the royal household deteriorated. By 2020, he and Meghan had stepped back from official duties. The following years brought interviews, documentaries, and a memoir. With those projects came renewed focus on past grievances. By 2021, legal filings began appearing. Harry launched multiple lawsuits, including actions against media organizations. These were not small claims. They were complex, expensive, and confrontational. Legal analysts noted immediately that timing would be an issue. Under UK law, most civil claims must be filed within 6 years of the claimant becoming aware of the harm. Courts may extend that window only in limited circumstances. Proving such exceptions requires evidence, not belief. That burden would later become decisive. What many observers missed early on was how much this strategy relied on a single assertion, that Harry had been prevented from acting sooner by forces beyond his control. If that claim failed, everything else would follow. This is where patterns began to emerge. Multiple cases, similar arguments, repeated reliance on emotional testimony over documentary proof. Each time the legal risk increased. By the time the January hearing arrived, the groundwork had already been laid. The question was no longer whether wrongdoing occurred in the past. It was whether Harry could still legally challenge it now. That distinction would prove unforgiving. The decisive moment unfolded over a series of hearings that many outside observers underestimated. According to people familiar with the filings, the core of the case rested on a narrow legal doorway. If that door stayed open, Harry could proceed. If it closed, the entire structure would collapse. The argument presented was specific. Harry's team acknowledged the claims were late. They did not deny the calendar. Instead, they argued the clock should be paused. Their reasoning centered on what they described as a private arrangement involving senior palace figures and media executives. According to Harry, this understanding discouraged legal action in exchange for future resolution. On paper, it was a dramatic assertion. If proven, it could have reset the legal timeline, but courts do not operate on implication. They require evidence, signed documents, written correspondence, verifiable records. What emerged during review was a problem that could not be solved with testimony alone. According to the judgment, no written proof of such an agreement was produced, no emails confirming its terms, no legal advice from the time referencing a binding commitment. Even former advisors named in the filings appeared unaware of any formal restriction. This absence mattered. The court examined contemporaneous records showing Harry had consulted lawyers years earlier. Notes indicated awareness of potential claims. This contradicted the idea of total restraint. The timeline became crucial. Court analysis reportedly focused on specific years when litigation could have been initiated. The judge noted that knowledge of hacking practices was already public by then. Other claimants acted. Harry did not. Legal experts watching the case pointed out that memory alone cannot override statutory limits. The law does not pause because someone believed waiting was wiser. It pauses only when action was genuinely impossible. As the ruling addressed this point, the implications expanded. Once the time bar was enforced, large portions of the case were struck out. Entire claims vanished. What remained was a shell. This is when financial consequences entered the picture. Under UK procedure, dismissed claims can trigger cost orders. The losing party may be required to cover legal expenses incurred by the defense. In high-profile litigation, those costs escalate quickly. Estimates discussed among legal commentators placed potential exposure in the seven-figure range. That figure included senior barristers, extended hearings, and document review spanning years. It was not symbolic, it was real. Notably, no immediate rebuttal followed. Harry did not issue a statement disputing the court's interpretation. His legal team did not announce an appeal that day. The silence drew attention. When public figures face unfavorable rulings, responses are usually swift. Clarifications are offered, intentions explained. Here there was nothing. This ruling did more than dismiss claims. It reframed the entire narrative. The issue was no longer press misconduct alone. It became about judgment, timing, and strategy. And as attention widened, comparisons surfaced that complicated the picture even further. As the implications of the ruling settled in, attention turned to a comparison that many believe Harry did not intend to spotlight. According to court records referenced during proceedings, he was not the only royal affected by unlawful media practices. Years earlier, his brother had faced similar circumstances. The difference lay not in the harm, but in the response. In 2020, Prince William quietly resolved his own claim against the same publisher. The settlement was handled privately, no public testimony, no extended hearings. The amount was not disclosed, but court acknowledgments described it as substantial. The matter ended there. This detail mattered because it undermined a central claim. Harry had argued that institutional pressure prevented earlier action, yet the settlement demonstrated that legal pathways existed. They had been used successfully. According to legal analysts, this shifted perception. It suggested that delay was not imposed uniformly. Instead, it highlighted differing approaches. One chose discretion and finality, the other chose confrontation and exposure. The court did not explicitly judge those choices, but the contrast was unavoidable. One path closed the chapter years earlier, the other reopened it with risk. Public reaction followed quickly. Media coverage emphasized the cost implications. Commentators questioned the strategy. Legal experts pointed to the difference between moral argument and procedural success. Within days, discussions emerged about financial strain. While Harry has significant resources, prolonged litigation drains capital quickly. Advances from publishing and media deals are finite. Legal bills are not. Industry observers noted another pattern. Each lawsuit reinforced the image of perpetual conflict. Brands, partners, and institutions tend to avoid uncertainty. Legal entanglements create it. Still, Harry remained silent. No clarification, no concession. His legal team declined repeated requests for comment. This absence became part of the story. Silence can signal many things. Sometimes it reflects caution, sometimes it reflects uncertainty. In this case, it left room for interpretation. Behind the scenes, sources familiar with high-profile litigation say discussions often continue after rulings. Appeals are considered, settlements explored, but each step carries cost and risk. This moment marked an escalation. What began as reputational concern moved into financial territory. The stakes had risen. And with that escalation came a new question. If the courts would not provide validation and the costs continued to mount, what would come next? The answer to that may determine whether this was the end of the battle, or only another chapter in a much longer conflict. By this stage, the situation had moved well beyond embarrassment. Legal consequences were now tied directly to future choices. According to people familiar with UK civil procedure, once costs begin to accumulate at this level, they can follow a litigant for years. Appeals do not pause billing. Further hearings increase exposure. Even partial losses can multiply financial pressure. This is where the broader implications became harder to ignore. Harry had framed these cases as necessary battles, but the law measures necessity differently. It asks whether action was timely, proportionate, and supported by evidence. When those standards are not met, intent becomes irrelevant. Financial analysts tracking high-profile litigation noted that the structure of UK cost orders creates a unique risk. Unlike jurisdictions where each side absorbs its own expenses, British courts can require full reimbursement. That includes senior counsel fees, document review teams, and extended court time. In a case spanning multiple years, that total can exceed initial estimates quickly. There were also professional consequences. Legal insiders pointed out that repeated losses on procedural grounds affect credibility. Courts remember patterns. Opposing counsel adjust tactics. Judges become less inclined to grant discretion. Publicly, the narrative continued to shift. Commentary moved away from media ethics and toward personal judgment. Questions arose about advice, about strategy, about whether emotion had overridden calculation. Still, no public response came. No statement challenged the framing. No explanation addressed the timing issue directly. This absence stood in contrast to the extensive commentary Harry had offered in other forums. It became increasingly difficult to reconcile the silence with the earlier certainty. Observers also noted the impact on those around him. Legal exposure does not exist in isolation. Family members are affected, business partners pay attention, institutions reassess risk. According to sources close to the situation, this ruling prompted internal reassessment. Not about the past, but about the future. How many battles remain worth fighting, what victories are still achievable, and what losses are now unavoidable. The legal system had delivered its answer. It was procedural, unemotional, and final in its own way. The question now was how Harry would respond to a system that refused to validate his narrative. That question remains open. And as long as it does, the consequences of this decision will continue to unfold quietly, away from cameras, but no less real. As of now, the situation remains unresolved in the ways that matter most. The ruling closed doors, but it did not offer closure. According to people familiar with post-judgment discussions, attention has shifted from arguments about the past to calcula. Tions about what comes next. Appeals are possible, but they are narrow. The window is short. The standards are high, and the costs increase immediately. What stands out most is what has not happened. No formal appeal notice has been announced. No public explanation has addressed the timing failures identified by the court. No statement has clarified whether further action is planned. For someone who has previously spoken at length about these issues, the absence is striking. When accusations are incorrect, responses are often immediate. Corrections are issued, narratives are challenged. Here there has been restraint. That restraint has fueled speculation. Legal analysts say silence at this stage often signals internal disagreement or strategic pause. Neither suggests confidence. Several questions remain unanswered. Why was litigation delayed when others acted sooner? Why was no documentary proof presented to support claims of restriction? Why pursue multiple actions with similar vulnerabilities? And why continue after early warnings became clear? Sources close to the case suggest observers are watching for specific signals. A quiet settlement, a narrowed appeal, or a complete withdrawal, each would communicate something different. There is also the question of legacy. Legal battles leave records, judgments are archived, findings persist. Future courts will see this history, so will partners, institutions, and the public. This story is no longer about phone hacking alone. It is about how power, timing, and expectation collide with systems that do not bend. It is about the limits of personal narrative when confronted with procedural law. What began years ago as a grievance has evolved into a test of judgment. The outcome of that test is still forming. The final image remains unchanged. A man exiting a courthouse in silence. No victory claimed, no argument offered, just the sound of doors closing behind him, and the understanding that some battles end not with resolution but with consequences that linger long after the cameras move on. What remains is the quiet weight of realization, not the kind that arrives all at once, but the kind that settles slowly after the noise fades and the practical reality takes over. For years, this legal fight was framed as unfinished business, a wrong that demanded correction, a past that could be repaired through persistence. But the court's response made one thing clear: the law does not revisit history on emotional terms. According to people who follow high-profile litigation closely, this is often the most difficult moment for a claimant, not the loss itself, but the clarity that follows it. The understanding that effort does not guarantee outcome, that sincerity does not replace timing, that belief, no matter how deeply held, cannot substitute for proof. This case revealed a larger pattern that extends beyond one courtroom. Again and again, the same approach appeared: public confrontation, moral framing, emotional investment, and again the system responded with indifference. Not hostility, not judgment, just rules applied as written. That pattern matters because it explains why the outcome feels so final, even without dramatic language. The court did not accuse, it did not scold, it simply declined to engage further, and in doing so, it removed the stage that had sustained the fight. Those watching closely understand what that means. Without a legal forum, the narrative loses leverage. There is no witness box, no ruling to anticipate, no symbolic victory left to chase. Only decisions about whether to continue spending time, money, and credibility on a path that has already narrowed. This is where the consequences become personal. Legal defeats reshape options. They influence future strategies. They change how allies advise. They redefine what is realistic. According to sources familiar with similar cases, this is often the point where escalation gives way to retreat, not publicly but privately. Still, nothing has been confirmed, no final move announced, no direction declared. That uncertainty keeps attention fixed, because unresolved situations invite interpretation, and interpretation fills silence quickly. The central question remains unanswered. Was this fight ever about winning in court, or was it about being heard? If it was the former, the system has spoken. If it was the latter, the cost of that pursuit has now been measured. History will likely record this not as a dramatic defeat, but as a lesson in limits. The limit of narrative, the limit of timing, the limit of persistence when it collides with structure. The doors of the court have closed, the ruling stands, and what follows will not be shaped by speeches or interviews but by choices made away from the spotlight. Those watching closely know this story is not finished, but whatever comes next will be different because the system has already given its answer. And that answer carries weight far beyond one lawsuit. It draws a line between grievance and remedy, between what feels justified and what the law is prepared to consider. For Prince Harry, that line has now been crossed, and it cannot be uncrossed. According to people familiar with how reputations are evaluated in institutional settings, this kind of outcome reshapes how future actions are interpreted. Courts will remember the timing issues. Opposing counsel will reference the pattern. Judges will approach discretion more cautiously. These things accumulate quietly, but they matter. There is also the personal cost that does not appear on any balance sheet. Years spent preparing for hearings. Emotional energy invested in outcomes that never arrive. The belief that one more appearance, one more filing, one more argument will finally deliver acknowledgement. When that belief meets finality, the adjustment is difficult. This is why the silence at the end feels heavier than any statement could. Silence suggests recalibration. It suggests the recognition that continuing down the same path may only deepen the damage. For someone whose public identity has been tied to speaking out, choosing not to speak can signal a turning point. Those close to the situation say the coming months will be decisive. Not because of another ruling, but because of what is quietly decided behind closed doors, whether to appeal narrowly or step back entirely, whether to pursue settlement or accept closure, whether to redirect focus or remain locked in conflict. None of those choices will reverse what has already happened. The judgment exists. The costs are real. The precedent is set. What remains is agency, the ability to choose a different direction. This story began with a belief that persistence would force accountability. It ends, for now, with the understanding that systems do not respond to belief alone. They respond to timing, evidence, and restraint. The image that lingers is simple and unchanging: a courthouse, a closed door, and a figure walking away without comment, carrying not vindication but consequence.